Finally, we talk about the means of restricting employee mobility that are outside of the non-competition agreement. Even without a non-competition agreement, a court can sometimes enjoin a former employee from working for a competitor using other means. The first of these is what's called the inevitable disclosure doctrine. And what the inevitable disclosure doctrine says that even if the parties don't have a non-competition agreement, if in fact it becomes certain that this person is going to use knowledge gained in one job in another job, if it is inevitable that those trade secrets will come out, I may be able to restrict that employee from his new job. I can go back in time, essentially, and create a non-competition agreement. The case on this involves IBM and then one of their employees who left to go to work for another company, a competitor to IBM. Now, there was no non-competition agreement between IBM and the former employee. Nevertheless, when the employee started the new job, he was sued by IBM, saying that the information you gained at IBM is going to come out at the new job. It's inevitable. The nature of the job means you're going to reveal that information. And the problem then is that that's unfair competition. And so courts have been willing to restrict employees from working in certain areas for a certain amount of time, and in effect imposing a non-competition agreement after the fact. So that's the inevitable disclosure doctrine. That's one of the means you as an employer can use to prohibit a former employee from working for a competitor. Now, this is restricted, of course. I mean, it's not always available, and you do have to establish that it will inevitably be disclosed. And oftentimes, new employers will say, look, we will erect walls such that this employee does not interact with anyone that he would share the information with, that would benefit. The other means of restricting employees is called the common law duty of loyalty. Now, this goes back to the basic nature of the employment relationship, meaning they are the master-servant aspect. Under the old master-servant relationship, the servant had an obligation to be loyal to the master, the duty of loyalty, and that was imported into employment law, such that the employee has a duty to be loyal to the employer. And how that works is that you as an employee cannot take any action that is detrimental to your employer, meaning that you cannot start planning your new job while working at your old job. You can't create your business plan and go out and seek financing and do all of these steps that you would take to start a new company until you leave your previous company. And of course, if you take any confidential information from your previous company and try to use it in the next job, you may see a claim for violation of the duty of loyalty. I had a case once where a person contacted me and said that he had changed jobs and that he was now being sued because his former employer didn't want him to work in the new job. So I said, okay, send me your non-compete. I'll look at it. I'll let you know if I think it's enforceable or not. And he said, well, there's no non-compete. And I said, well, there's no non-compete. What is this based on then? And when I looked at the actual petition, it turns out that this prospective client had actually stolen a bunch of confidential information in terms of customer list and price list and was going to use it at the new employer. And therefore, they were prevented from doing so. I did not wind up taking the case in large part because I thought this was a pretty shady thing to do. So the common law duty of loyalty is a means to restrict employees. Make sure you know these two for your test purposes because it's easy to ask about. And it's important for you as an employer to know these things as well. Now, finally, we leave off this idea of what are the ramifications of the widespread use of the non-compete agreement. As I mentioned, more and more states are permitting non-competition agreements. And those non-competition agreements are getting broader and longer and with applying to more geographic areas. What does that mean? What's going to happen from that? Again, everyone who enters into, every state always has this notion, every state that enacts these statutes has this notion that this is friendly to business and therefore we should do it. But in fact, it may not be that way at all. If you were to look at the United States and which state has had the most dynamic economy over the last 20 years, there's a good argument that that's California. Silicon Valley arose in California. Now, why is that? Well, you could argue that there's good schools in that area. It's a attractive area. It's a place where people want to live. So that's one argument. But the other argument is that because California doesn't allow non-competes, what that means is that a person is free to take the knowledge that he learned at Cisco and take it to Apple and use the knowledge there. Cisco, however, is able to hire an employee from Yahoo to come in and replace that. And so there's this shared ability of employers to benefit from the previous experiences of their employees. It's the notion of a rising tide lifts all the boats, that it's good for everybody. That if you as an employer are harmed because you lose a good employee, well, that means you can go out and find another equally good employee. It also encourages employers to treat their employees better because you don't have this stick of preventing people from leaving. You have to rely more on the carrot aspect. So when you look at a business like Google, who offers, daycare and cafeterias and great benefit plans, well, it does so in part because it needs to keep those employees. And so this is a good example of how legal infrastructure, this decision of how we enforce non-competition agreements, is it beneficial or not? There was a great case study available on this exact issue involving the state of Michigan. And the state of Michigan, the legislature accidentally eliminated the ability to enforce a non-competition agreement. The language wasn't included in the new bill. No one caught it. And so suddenly Michigan changes from a state that enforces non-competition agreements to a state that doesn't enforce non-competition agreements. This goes on for about 7 years, and then the new legislature comes in and puts back the old language. But for this time period, when you do the analysis, it turns out that from a financial, economic perspective, Michigan did much better during those years when it did not enforce non-competition agreements. So the lack of the ability to enforce a non-competition agreement could actually improve the business climate of a state. It's something to think about. Several studies have showed that the non-compete agreement is actually a drag on a state's economy. By preventing the free flow of workers from job to job, that's inhibiting the employers that are there and ultimately provides a drag on the state's economy. Finally, we come to the last thing, and I've uploaded a document on D2L that you should really look at in terms of drafting an enforceable non-compete agreement, because again, that's what I'm going to have you do as part of your writing assignment. And the first is to identify the parties and the interests being served. If you want to ensure your non-competition agreement is enforceable, one of the things you will do is to make it as specific as possible. Identify the parties and then identify what is the purpose of the agreement. Why is it that you as an employer are trying to restrict this particular person from working for a competitor? So if you identify that in the agreement itself, the court, who is going to look at it one day, doesn't have to do a lengthy analysis of trying to figure out what this was about. And if we make them specific, meaning we don't use just the same generic form, employee promises and employer promises, if you make it specific, then you can argue that this was tailored in order to protect the employer while at the same time acknowledging the interest of the employee. You will then create reasonable restrictions on scope, geography, and time. And I explained all of those ideas. It has to be the context of the job, the position. Reasonableness is not something that we can define one way or the other. It's one of those things that you'll know it when you see it kind of thing. But you'll have to put in those 3 restrictions on your non-competition agreement. And finally, think about including a step-down agreement. Again, I don't like them. I don't feel like they are good drafting, examples of good drafting. But it may be something that you want to consider in your own non-competition agreement. So what did we learn in here? Most employers will seek to retain employees by any means. Employers want to retain employees. The common law approach to non-compete agreements is going to be based on the idea of reasonableness. And reasonableness has these 2 aspects of a legitimate business purpose and scope, geography, and time restrictions. So reasonableness is how we restrict enforceability. And finally, know that enforcement of a non-compete agreement varies from state to state. There are 50 different sets of non-competition laws, and you as an employer are going to have to be cognizant of those wherever you're doing business. And that's it. Thanks for listening.